Good day, class. I want to welcome you to our discussion on the law on agency. All right. For our classroom purposes, the law on sales and the law on agency are merged into one subject. But when you get to law school, they are separate subjects. There is one entire subject dedicated to the law on sales, and there is one subject dedicated entirely on the law of agency. But for college purposes, we will need to know the basic laws regarding each. So we're finished with the law on agency. Oh, sorry, rather, we're finished with the law on sales. And now we begin with the law on agency. So what is the concept of a contract of agency? It's where a person is given power to contract with a third person on behalf of another person. All right, so we encounter this all the time. Okay, let's say you have a business. Okay, and then you're in the business of selling fruits. Okay, so you are the owner of those fruits and you sell those fruits. However, your time is limited. So what do? You hire people. You hire people for you to sell those fruits for you. Okay? So hindi naman kailangan na ikaw dapat yung magbenta pa. No? So yung mga tao na hinar mo, so they are like your agents. So they collect money, they hand out the fruits. So they act as if you are the you they act as if you are the person who is selling. No? Okay. So we have this contract of agency to promote commerce and to eliminate dead weight losses. Okay? So kasi paano kung nasa abroad ka, tapos kailangan mo meron mag-aasikaso ng papers mo or paano kung let's say busy ka ganyan. So you can have agents to do work for you. So what are the characteristics of a contract of agency? Number one, it is consensual. It is consensual because it is perfected by mere consent. There is no required form, all right, in a contract of agency, except in certain cases like sale of real property through an agent. It has to be written. So sale of real property through an agent, the authority must be in writing. Otherwise, the sale is void. All right? Palaging lumalabas yun sa board exams ng CPA board exams. No? Number two, it is a principal contract. It can stand by itself without the need of another contract. Number three, it is nominate. It has its own name provided by law. So parang sales, no? We have the law on sales. Ito naman, we have the law on agency. It is unilateral if it is gratuitous. If there is compensation, then it will become bilateral. Right? It is preparatory because it is entered into as a means to an end, such as the creation of other contracts. So typically when you sell property, so you give the agent authority to sell your property. So that's why it's preparatory because eventually you want a contract of sale. Right? So bibigyan mo na ng authority yung agent mo in order for there to be a valid contract of sale. So what are the essential elements of an agency? Number one, there is consent, expressed or implied, of the parties to establish the relationship. So take note class, no, express or implied. Kasi when na-express, malinaw na sinabi ng principal, okay, you are authorized. Sabi na sa agent niya, you are authorized to act for me. Okay? Pwede bang implied? Yes, pwede implied under the law. Alright? So let's say ikaw yung principal, tapos pinapabayaan mo lang yung tao na mag-transact sa'yo, nakita mo, tapos pinapabayaan mo lang. So isipin ng third persons, isipin ng ibang tao, teka parang ahente pala to, parang paig pala yung principal na ganyan. Kasi hindi ka nag-object eh. Sabihin hindi mo siya tinitigil na mag-act para sa iyo. So sabihin there is implied authority. Number two, the object is the execution of a juridical act in relation to third persons. Class, to take note, it's juridical act, not judicial act. Okay, juridical act, any act which may, come under the lens of the law. No. Number three, the agent acts as a representative and not for himself. So malinaw to class, no? The agent is not acting in his own name. The agent is acting in representation of the principal. Number four, the agent acts within the scope of his authority. So this is important class, no? So ang agent dapat, lalo na pag limited yung authority niya, dapat dun lang. Dapat yun lang yung, dapat dun lang gumawa yung agent. For example, si P, the principal, authorized A, the agent, to sell his car for 500,000 pesos. Pwede ba ni agent ibenta yung kotse ng 500,000 pesos sa ibang tao? Yes, kasi meron siyang authority, no? Na ibenta yon. Pwede ba niya to ibenta ng 600,000 pesos? The answer is yes, class, no? Bakit yes? Because it is beneficial for the principal. Okay? So yung extra ng 100,000, kanina mapupunta? Sa agent ba? Kasi good boy siya, kasi magaling siya magbenta? The answer is no. Alright? The excess still goes to the principal. Okay? Unless, of course, pumayag yung principal na ibigay yung agent. Pero kung silent, kung wala silang pinag-usapan, any and all extra benefit has to go to the principal. Using the same example, pwede ba ibenta ng A? Pwede ba ibenta ng agent yung kotse sa ibang tao ng 400,000? The answer is no. Alright? Kasi labas sa authority ng agent. Okay? Paano kapag binenta pa rin ng agent? Mananagot pa siya dun sa 100,000 pesos? Pero the answer is yes. Okay? Mananagot yung agent dun sa principal ng 100,000 pesos. O take note class, pag kulang, mananagot yung agent dun sa kulang. Pero pag sobra, hindi yun mapupunta sa agent. Mapupunta yun sa principal. Alright? So who are the parties to the contract of agency? Number one, the principal, one whom the agent represents and from whom he derives his authority. Number two, the agent, one who acts for and represents another. He is the person acting in a representative capacity. So dalawa lang yan, no? The principal and the agent. So the general rule is anything can be the subject of a contract of agency, but there are exceptions. What are those exceptions? For personal acts. If personal performance is required by law or public policy or the agreement of the parties. Okay? So ito mga personal acts na dapat na hindi pwede i-delegate. Number one, right to vote during election. No, hindi mo pwedeng sabihin sa let's say wala ka sa Pilipinas or busy ka, hindi mo pwedeng sabihin na hindi mo pwedeng sabihin sa parents mo or to whomsoever person, no? Hindi mo pwedeng sabihin, ikaw na lang pumoto para sa akin. O para wala tayong pila. Para hindi tayo dumagdag sa pila, para iwas COVID din, para ganyan. Hindi pwede yun, class, okay? You cannot delegate that authority. You have to vote by yourself. That is required under the law. All right? So right to vote during the election. Okay? Making of a will. You know what a will, class, is? No? Huling habilin, the last will and testament. Hindi mo pwedeng ipaubaya yan sa ibang tao. All right? And then statements which are required to be made under oath should be made personally. Let's say magpapanotaryo kayo. Ganyan. Hindi pwedeng magbibigay. I've encountered this so many times, class, no? Ang daming gusto magpa-notarize sa akin ng documents, pero wala naman yung nakapirma. Ang gusto pa nila, magbigay na lang ng authorization letter para notaryuhan ko. I do not accept that, class. Okay? Because under the rules, under our laws, pag notary public, right? You have to appear before the notary public. Okay? Kailangan malaman ng lawyer, ng notary public, kung talagang pirma mo yan. Paano malalaman niya pirma mo yan? Well, the best way to do is, ikaw mismo yung pumunta doon. No? Okay? Tapos okay, pipirma ka sa harap ng notary public, ng lawyer. Alright? And the marriage ceremony. So hindi pwede class yung ano, no? Hindi pwede yung ay busy ako sa wedding ko, hindi ako pupunta. Kasi pag ano mangyayari, pag iba yung pupunta sa ano sa wedding ceremony, baka hanggang honeymoon kasama. I'm just kidding, class. All right. So number 2, criminal acts or acts not allowed by law. If such act by the principal is illegal, then the delegation to the agent is also void. All right. Example ito, an alien cannot purchase land through an agent. Alright? So class, ang mga foreigners, no, ang mga aliens, they cannot buy land here in the Philippines. Okay? But they can buy condominium units. That is okay. Pero pag land, hindi pwede. They can only lease. Pwede lang sila magrenta, but they cannot purchase land. Alright? So hindi sila pwede mag-hire ng, kunwari, ng tao ng agent para bumili in their behalf. Okay, so again, class, no? So the general rule is anything can be the subject of a contract of agency, but there are exceptions. Agency may be implied from the circumstances. All right, so acts of the principal. A sold the goods belonging to P without the consent of the latter. With knowledge of the facts, P received the proceeds of the sale and even gave A commission. The acts of P constitute ratification, thereby giving the contract the same effect as if he had originally authorized it. So nakikita nyo, class, no? Hindi talaga pumayag si P. But because of the assent, dahil sa kilos ni P, dahil sa kilos ng principal, dahil sa actions niya, okay, he is precluded from denying the agency. Apparently, he is stopped, no? The principal is stopped. So we will encounter that later, no? It's a very common legal concept, class, no? Estopel. All right, if you read court cases, etc., you will always encounter the word estopel. Because by the assent of the principal, parang pumapayag din siya na may authority si A na magbenta sa kanya. Okay? So again, class, no, there is implied authority in this case. Okay? So there is ratification. What is ratification? Parang pagpayag, no? The acts of P constitute ratification, thereby giving the contract the same effect as if he had originally authorized it. Right? Agency may be implied from the circumstances. Number 2, the principal's silence or lack of action or failure to repudiate the agency. Kumbaga hindi siya nag-o-object. Hindi niya tinututulan yung agency. Okay? And may naapektuhan ng third person. So that third person has to be protected. So the class, no, P's property was being administered by A. Later, B took charge of the administration of the said property through the designation by A, who had to make himself absent from the place for reasons of health. P did not oppose the designation of P, nor did P appoint a new agent, although the designation was expressly communicated to him. He remained silent for 1 year, allowing B to take charge of the property. It must be concluded that B acted by virtue of an implied agency equivalent to a legitimate agency tacitly conferred by P. Okay? So class, no, by the acts of the principal, okay? Let's say hindi siya nag-object, hindi siya nagre-reklamo, so parang pumapayag siya. So pag ganun, class, no, it's as if may authority na rin yung agent. Okay? Kung ayaw magbigay ni P ng authority, ano dapat ang gawin niya? Talaga tutulan niya yan. Kasi otherwise, kapag hindi niya tinututulan, kapag pinapabayaan lang niya, it's as if nagbigay siya ng authority. Okay? Ibang usapan, class, kapag talaga yung principal, wala talagang alam, hindi niya alam na yung tao ay nag-act in his behalf, no? In that case, the principal will not be liable. Pero in this case na na tahimik lang yung principal, hindi siya nag-o-object, alam niya yung nangyayari, the principal is stopped. All right? There is an implied contract of agency. Okay? So how do you communicate the existence of an agency? Number one, by special information. The person appointed as agent is considered as such with respect to the person to whom it was given. Okay? So for example, sinabi ni, let's say si P yung principal, si A yung agent, tapos si B yung third person. Si P sinabihan niya si B na oy B, si A yung agent ko. So you can transact with him in my behalf. Okay? So alam ni B yung yung contract of agency between P at saka A. All right? So that's special information. Number two, by public advertisement. The agent is considered as such with regard to any person because it's a public advertisement. A public advertisement may be made in any form, like through the newspaper, radio, posters, or billboards. Okay? So you have to take note, class, no? Kasi mapansin niyo wala dito yung paano kung sa Facebook or sa social media. Remember, class, no? The Civil Code was enacted in 1950. During that time, medyo sobrang simple pa ng mga computers noon, let alone wala pang internet, wala pang email. But now kasi, puro public advertisement. But you think it's still valid? Pwede pa rin ba yun? If it can be proven, class, na alam ng third person, no, na may authority yung agent, then it should be okay. Alright? But usually, yung public advertisement, ginagawa sa dyaryo, sa newspaper of general circulation. Alright? Ba't may nagbabasa po ba ng dyaryo ngayon? Yun yung sinasabi ng batas natin. Okay, so that's public advertisement. So pwede sa radio, posters, billboards. Yan. Pwede ba i-revoke ang agency, class? The answer is yes. The agency can be revoked at any time, except under certain circumstances, which we will discuss later. Okay? The power of attorney. So ito, class, na usually makikita nyo contract of agency, mga binibigay sa SPA. No? What is SPA? Special power of attorney. We will discuss that later. So the power of attorney must be revoked in the same manner in which it was given. Okay? So sabihin, class, kung nagbigay ka ng kung pinaalam mo yung contract of agency through special information, dapat ipaalam mo rin through special information na revoke na yung agency. Ngayon, paano kapag in-announce mo yung contract of agency through advertisement? Okay? Dapat ipaalam mo rin yung revocation ng agency through advertisement din. Okay? To make the revocation effective. Okay? So again, no? So the power of attorney must be revoked in the same manner in which it was given. If it is not revoked in the same manner, the revocation will be without effect. However, the revocation will be effective if the third person has actual knowledge of the revocation. But of course, class, no, you will have to prove this in court if ever tumating man kayo sa kasuhan. Okay? So dapat ma-prove ng principal, no, na alam nung third person na na may knowledge siya ng revocation ng agency. Okay? So how do you prove that? Well, it's on a case-to-case basis. All right? But what the law provides is, no, kapag nag-advertise ka sa radyo, tapos nag-revoke ka sa radyo, then that should be okay. All right? Kung nagbigay ka ng special information about the contract of agency, tapos binigay mo rin yung information ng revocation by special information, that should be okay. All right? Paano kapag nagbigay ka ng special information about the contract of agency, pero in-announce mo yung revocation through advertisement? Hindi pwede yun, class, no? The principal is still bound by the acts of the agent pag ganun. Or paano kapag advertisement, no? Through advertisement, tapos pinaalam mo dun sa tao na na-revoke na yung agency. Pinaalam ng principal dun sa tao na revoke na yung agency. Is the principal still liable? O take note class, no? Kung alam na nung third person na ano na revoke na yung agency, okay? Hindi pa rin pwede. Right? Sabihin, liable pa rin yung principal. Hindi na liable yung principal. Okay? Basta may knowledge na yung third person about the revocation of the agency. Okay? Hindi na liable yung principal doon. Alright? So this is important class, no? Especially for BSA students who will be taking the board exams. Dapat ngayon pa lang malaman nyo na to. Sale of land through an agent, right? Sale of a piece of land or any interest therein, like use of rock, mortgage, etc., through an agent is void unless the authority of the agent is in writing. Right? Paano pag verbal lang? It's still void. Okay? It has to be in writing. Okay? So yung class, no? So, kasama dito yung kapag mag-enter ng contract of use of rock or mortgage, you already know what mortgage is. No? Pagsasangla. What is use of rock? Ang use of rock class, no? Pinapahiram mo yung lupa mo nang walang kapalit. No? So that is use of rock. Kasi parang kapag pinapahiram mo yung lupa mo, tapos may bayad naman, that is a contract of lease. Okay? Pero pag pinapagamit mo yung lupa mo na walang bayad sa'yo, that is a contract of use of rock. Alright? So the agency to purchase need not be in writing. Alright? So agents classified. Number one, universal agent. Authorized to do all acts that the principal may personally do and which he can lawfully delegate to another the power of doing. So ito parang lahat ng acts na pwede na gawin ng principal, pinapaubayan na sa agent niya. Is that advisable? Well, I wouldn't advise it. Number two, general agent. Authorized to transact all the business of his principal or all business of a particular kind or in a particular place, or in other words, to do all acts connected with a particular trade, business, or employment. So pag general agent class to, ano yung document na hawak niya? Usually, general power of attorney. So class no, iba yung general power of attorney sa special power of attorney. So ano naman yung special or particular agent? Authorized to act in one or more specific transactions or to act upon a particular occasion. So ito naman class, anong document naman to? SPA. Alright? So ang SPA class, meron lang specific acts. No? Na yun lang ang pwede na gawin. Nagkagawa ng SPA for the agent to sell your particular property. Okay? Ano document kapag gusto mo bigyan yung agent ng authority na i-handle yung negosyo mo, i-handle yung business mo? That is a general power of attorney. Okay? So an agency couched in general terms, it includes only acts of administration, even if the principal states that he withholds no power. The agent may execute such acts as he may consider appropriate, or if he authorizes a general or unlimited management. So class, no? We have to know first what are acts of administration. Acts of administration are acts that are done in the daily life of the business. It's the selling of merchandise, it's the purchase of supplies. Yun ang mga acts of administration. Ano naman yung acts of dominion, class? Acts of dominion, let's say you're selling the land where the business is. That is an act of dominion. For example sa book nyo, no? What if ang business ng principal is tailoring? Alright? So ano ba yung mga kagamitan sa isang tailoring shop? The answer is a sewing machine. Pwede ba basta-basta ibenta ng mananahay yung sewing machine? The answer is no. Alright? Kasi that's an act of dominion. Pag wala yung sewing machine, wala yung negosyo. Paano kapag ang business pagbebenta ng sewing machine? Tapos nagbebenta yung agent ng sewing machine. Is that an act of administration or an act of dominion? That is an act of administration. Because yun yung negosyo, pagbebenta ng sewing machine. Pero pag tailoring ang negosyo, no? Pwede mag-accept yung mananahi ng customers, pwede siya magsukat, because those are acts of administration only. Alright? Paano pag nasa real estate company class, no? Tapos yung ahente nagbibigay ng mga, yung mga ahente nagbebenta ng mga lupa. Imagine the people from, from real estate companies like Avida, Calmar Land, etc. Yung mga agent na yon, for every sale, kailangan ba nila ng SPA? The answer is hindi na legally kailangan because those are acts of administration. The company is in the business of real estate. So ano binibenta nila? Lupa talaga. Right? So in class, you have to differentiate between acts of administration and acts of dominion. The meaning of acts of administration, it is a question of fact. It's even case-to-case basis. No? A person employed to sell goods in a retail store can sell without special power of attorney because selling itself is an act of administration. An attorney, in fact, empowered to pay debts of the principal and to employ attorneys is impliedly empowered to pay attorneys' fees. And those are acts of administration. So when are special powers of attorney necessary? Number one, to make payment not in the ordinary course of management or administration. Example is the purchase of land for expansion. Let's say you want to expand your restaurant business, etc. The agent needs to have a special power of attorney from the principal. Number two, to effect novations, such as a modification of an existing obligation. Let's say substitution of a debtor. So that's a novation. So you learn that in your obligation. Number three, to compromise. Reciprocal concessions to put an end to litigation. So sa court cases class, uso ang compromise. No? Imbis na ituloy ang kaso, nagko-compromise na lang yung mga parties. You think the lawyer can just go ahead and compromise on behalf of his client? The answer is no. Kailangan ng lawyer ng SPA. No? Na binibigyan siya ng authority ng client niya na makipag-compromise sa kalaban. Number four, to waive an obligation gratuitously. The agent cannot waive a right belonging to the principal without authorization. For example, class, no? Let's say nagpapautang ka, you're in the lending business. Tapos meron kang ahente, nagka-collect ng pera. Tapos itong ahente, kaibigan niya yung isang umutang sa'yo. Sabi ng ahente, pare, huwag ka na magbayad kasi ako na bahala sa'yo. Pwede ba yun, class? The answer is no. Alright? Para magawa yun ng ahente mo, kailangan niya ng special power of attorney. Kailangan niya ng SPA to bind the principal. Anong nilalaman ng SPA? Dapat ang nilalaman ng SPA, dapat merong authority yung agent, no, na ipawalang bahala na yung utang, yung particular na utang na yun. Kung wala siyang ganun, hindi pwedeng gawin ng agent yun. Alright? Number five, to convey or acquire immovable property. Okay? So kailangan ng authority ng agent. No? Kailangan ng SPA. Pag lupa, kapag immovable property ang pinag-uusapan. Number six, to make gifts. Number seven, to loan or borrow money unless the latter is needed urgently to preserve things under administration. Alright, so let's say utang ng pera in behalf of a principal, kailangan syempre ng authority, kailangan ng SPA. Okay? Alright, class, no? So parang kapag business ka, tapos let's say you're in the rice trading business. Okay? Tapos yung tauhan mo, yung agent mo, kasi mag-out of stock na kayo. So ginawa niya, kumuusap siya ng supplier para mag-order on credit. Nang sabihin mag-order, tapos di pa niya babayaran. So parang di may utang ka. Pwede ba yun, class? Kahit walang SPA yung agent? Answer is yes, pwede. Okay? Kahit general authority na meron sa kanya, okay lang yun. Pero parang pag-uutang, no? Parang pag-uutang, let's say meron kang kapatid, no? Tapos nangangailangan ng pera. Tapos ikaw, uutang ka ng pera in behalf of your kapatid, in behalf of your brother or sister. Okay? Pwede ka ba umutang sa pangalan niya? The answer is no, of course. Kailangan ka niya bigyan ng SPA. If wala binigay yung SPA, hindi ka pwedeng umutang ng pera para sa kanya. Alright? Number 8, to lease property for more than 1 year. So in this case, class, no? So kailangan apparently ng SPA. Okay? Number 9, to bind the principal to render service gratuitously. To bind the principal in a contract of partnership. To obligate the principal as a guarantor or surety. So class, do you know the difference between a guarantor and a surety? So a guarantor, we learned this in obligate. A guarantor answers for the miscarriage of debt by another person. Sabihin, kung hindi makapagbayad ng utang yung tao, tapos meron siyang guarantor, yung guarantor magbabayad. Okay? Ano naman ang surety? Okay? A surety is solidarily liable with a debtor. Alright? So pag let's say si meron debtor, no? Yung creditor, pwede siya dumiretso agad sa surety para masingil yung utang. Okay? Pero pwede ba ang creditor na dumiretso agad sa guarantor? Hindi pwede. Dapat dumaan muna siya sa debtor. Tapos kapag hindi makapagbayad yung debtor, saka magiging liable si guarantor. Okay? So yun yung difference ng guarantor at saka surety. Alright? Number 12, to create or convey real rights over immovable property belonging to the principal, to accept or repudiate an inheritance, to ratify obligations contracted before the agency, and any other act of strict dominion. So class, now these are the cases na kailangan ng special power of attorney. Okay? Hindi pwedeng in general terms lang yan. Dapat specific dito sa mga to. Okay? So yun ang special power of attorney. So when is the principal bound by the acts of the agent? When the agent acts within the scope of his actual or apparent authority, or kapag lumampas ka sa authority but there is ratification by the principal. So class, itong ratification by the principal, lagi itong lalabas. No? Kasi what if the agent acted outside his authority, pero pumayag naman yung principal, then the principal will still be bound. Okay? Or the performance of the agency is more advantageous to the principal. Kaya na example natin earlier, paano pag yung kotse na pinapabenta mo sa agent, nabenta niya na mas mahal sa presyo na gusto mo mabenta, okay lang yun. That is still valid. Pero balik tayo sa same example, 500,000 yung kotse, pero binibenta ng agent ng 100,000 pesos lang. Alright? Tapos alam nung third person na 100,000 pesos lang sorry, 500,000 pesos dapat yung presyo. Okay? Hindi pwede maging liable yung principal. Hindi pwede pilitin si principal na ibenta yung kotse na 100,000 pesos lang. Alright? Kasi ikaw naman as a buyer, no? Tapos ang transaction mo as ay agent lang. Kasi may gusto ka bilhin lupa. Anong unang dapat mong gawin? Syempre dapat makita mo na yung title sa property kung nasa pangalan nga ng seller. Tapos anong next mo gagawin? I-check mo yung SPA niya. Dapat kunin mo yung SPA, but dapat basahin mo mabuti. Right? Kasi ang SPA class, it can include the price. Pag nandiyan yung presyo, ibig sabihin, dapat susundin yung presyo. Pero paano kapag ang sinabi nung sa SPA, the agent can sell at whatever price that the agent wants? Is that okay, class? That is okay. Kasi nagbigay ng authority yung principal dun sa agent na mag-set ng presyo. That is okay. Alright? What is the effect if the agent acts beyond the scope of his authority? The contract is unenforceable, except if the performance of the agency is more advantageous to the principal, or if the principal ratifies the act of the agent. Okay? So again, the contract is unenforceable. Hindi pwedeng pilitin yung principal na maging liable dun sa kanyang obligation. What is the effect if the agent acts in his own name? The general rule is The agent is the one directly liable to the person as if the transaction were his own. All right? But the exception is if the contract involves things belonging to the principal. This is necessary to protect third persons against possible collusion between the agent and his principal. So you will notice, class, no, there is particular importance given to third persons. Okay? So class, no, talaga namang hindi dapat liable ang principal, no? Kapag wala namang authority yung agent or if the agent exceeded his authority. Okay? So in that case, lalo na what if yung agent is acting in his own name, then only the agent is liable. Except if the thing belongs to the principal. All right? Now, if the thing belongs to the principal, tapos malinaw naman na walang authority yung principal, hindi liable yung principal. Pero kung yun nga, if stopped yung principal, if stopped yung principal, then the principal will be liable. So power of agent to appoint sub-agent or substitute. The general rule is the agent may appoint sub-agent or substitute. Okay? The exception is if the principal prohibits substitution. So dito class papasok yung sub-agent, no? So for example, si P, in-appoint niya si A as agent. Eh si agent, no, dahil busy si agent, nag-appoint niya ng agent niya. Is that okay, class? The answer is yes, that is okay. So ang tawag doon ay sub-agent. Okay? Alright? Bawal lang yan kapag pinagbawal ng principal. Bakit naman siya ipagbabawal ng principal, class? Kasi pwedeng hindi kilala ng principal yung sub-agent. Posible na ang tiwala lang niya nasa agent lang. Alright? So usually pag gagawa ng SPA, no, it has to be clear kung bawal mag-appoint ng sub-agent yung agent. Or kung gusto naman ng principal na clear na pwede mag-appoint yung agent ng sub-agent, gagawin niya, bibigyan ng power ng substitution yung agent. That is okay. That is okay in many documents of SPAs. No? Merong power of substitution yung agent. The power of agent to appoint sub-agent or substitute. If the substitution is prohibited, the agent exceeds the limits of his authority. If the agent is given the power to appoint a substitute, the agent is liable if the sub-agent chooses is notoriously incompetent or insolvent unless the principal himself has designated the substitute. Okay? So class, no, in this case, no, if nag-substitute nga yung agent, no? Tapos yung kinuha pala niya is notoriously incompetent or insolvent. Class, take note of the wording. Hindi pwedeng basta pabaya lang. The wording is notoriously incompetent or insolvent. Anong sabihin ng notoriously incompetent? Talagang hindi kaya i-carry out yung obligations niya. No? Insolvent, the definition of insolvent is liabilities are greater than the assets. Okay? So yun yung sabi ng batas, no? So in this case, the agent will be liable for the acts of the sub-agent in that case. The substitution is neither authorized nor prohibited. The substitution is valid insofar as the principal is benefited. If there is damage to the principal, the agent is liable. Okay? So dito lumalabas, paano kapag silent? Paano kapag silent yung batas? No? Let's say silent yung agreement ng contract of agency, pero nag-substitute pa rin yung agent, pwede ba yun? Answer is yes, pwede. Okay, as long as the principal is benefited. Pero kung may damage dun sa principal, mananagot yung agent. So when may the agent incur personal liability? Number one, when the agent expressly binds himself, or when the agent exceeds his authority, except when the power of attorney by the principal is shown and made known to the third person. Okay? So in class, no? Paano kung yung agent na let's say yung agent ay nagbebenta ng kotse, no? Tapos sinabi niya dun sa sa gusto bumili na ma-deliver ko yung kotse in 2 days. Ako mananagot kapag hindi na deliver in 2 days yan ng principal. So in that case, class, no? In that case, mananagot yung agent dyan because he expressly binded himself. No? Kasi kunwari sinabi ng agent na, o ganito, promise ko na nandiyan na yan bukas. Otherwise, I'll be liable for any damage you may sustain. In that case, mananagot si agent dyan. But otherwise, no, kung hindi naman niya, let's say, nagkaroon talaga ng delay sa principal, yung principal yung mananagot doon, not the agent. Or when the agent exceeds his authority, no, except kapag alam nung third person na wala na nag-exceed ang authority yung agent. Right? Kasi pag nangyari yon, hindi maging liable si agent or yung principal. Okay? So what is the effect where the third person is aware of the limits of the agent's powers? If the agent acts in excess of his authority, the contract is unenforceable as against the principal and void as against the agent and the third person. Right? So take note, class, no? Malaking difference yung unenforceable sa void. Right? Kapag void class, a void contract is not subject to ratification. Pag unenforceable, it is subject to ratification. If the agent promised to secure the principal's ratification but fails, the agent is personally liable. If ratification is obtained, the principal becomes liable. Right? So very important dito yung ratification class. When an agent's lack of authority is not available as a defense to a third person, when the principal has ratified the contract. Okay? So class, parang sa parang let's say balik tayo sa example ng kotse na binebenta ng agent for let's say for 600,000 pesos. Okay? Tapos tinanggap ng third party. Okay? Tapos gusto pala niya mag-back out, no? Parang nagpirmahan na and everything. Hindi pwedeng sabihin ng third person, teka, nag-exceed ka ng authority mo kasi 600,000 pesos lang yung presyo. 500,000 pesos lang yung authority ng principal mo. Paano kapag pumayag na si principal doon sa 600,000? So in that case, the third person cannot use the defense, no, of the agent's lack of authority. Right? So the presentation of power of attorney or instructions as regards the agency. The third person must inquire as to the extent of the agent's authority. It is the third person's duty to require the agent to produce his power of attorney to ascertain the scope of the agent's authority. However, the third person is not bound by the principal's private instructions. So class, makiwala yung instructions dun sa authority. Right? Kasi instructions, pwedeng ito lang yung manner of how to deliver the object or whatever. No? Pero yung authority, it has to be clearly provided for. Okay? So class, if you're dealing with an agent, you have to make sure, if you want to bind the principal, you have to make sure na may authority nga talaga yung agent. Okay? So wag kayong magpapaloko, class. Ang daming naloloko na kunwari agent sila ng, for example, St. Peter, ganyan, yung mga life plan, tapos bayad ka ng bayad. Tapos yung pala, wala, no? Hindi pala alam ng St. Peter na nagbebet na nagbabayad ka ng plano. So in that case, you cannot, it cannot prejudice the principal or St. Peter in this case, no? Hindi mo pwedeng pilitin, teka, nagbabayad naman ako, so dapat nasa yung pera. Paano kapag wala talagang authority yung agent? So it cannot bind the principal. So you have to be careful, no? Hindi pwede yung magbabayad kayo kung kani-kanina lang. So what is agency by estoppel? So let's discuss first what estoppel is, no? Estoppel is a bar which precludes a person from denying or asserting anything contrary to that which has been established as truth by his own deed or representation, either expressed or implied. So for example, sinabi na ng principal na agent niya si A, no? Tapos naniwala yung ibang mga tao. Alright? Tapos dahil dun sa paniniwalang yon, nakipag-transact sila sa A. So nakipag-transact sila kay A, the agent. No? So in that case, no, hindi pwedeng sabihin ni yung principal, teka, joke lang yan. Wala man talaga akong authority na binibigay kay A. Hindi yun pwede, class, no? Because the principal is stopped. Alright? So hindi pwede yung mga biro na ganun-ganun. So why do we have agency by estoppel? It's to protect third persons. If the estoppel is caused by the principal is liable. Okay? So to class, no? What are the modes of extinguishment of an agency? By the revocation of the principal. So class, no, the principal can revoke his authority to the agent anytime, except under certain circumstances, which we will discuss later. Number 2, by the withdrawal of the agent. So the agent can withdraw anytime. Hindi mo pwedeng pilitin yung agent na magbenta. Okay? Because that's going against our right against involuntary servitude. In the same manner, no? Hindi mo pwedeng pilitin yung tao na magtrabaho sa'yo. Hindi mo pwedeng pilitin yung tao na gumawa ng isang bagay. No? So ano pwede mong gawin? Pwede mong huminga ng damages. Alright? So the agent can withdraw at any time. So number 3, by the death, civil interdiction, insanity, or insolvency of the principal or of the agent. So ito class, I've encountered this so many times, no? May let's say may bentahan ng lupa, tapos may SPA, no? Yung sa SPA, patay na pala yung principal. Right? So pag hindi pwede yun. Alright? By the death of the principal, the contract of agency is extinguished. So you have to remember that class, no? If may pagtatransact kayo ng properties, ng real properties, pag patay na yung may-ari ng lupa, hindi pwedeng may SPA yon. Okay? Ibang dokumento na ang kailangan para matransfer yung lupa. So number 4, by the dissolution of the firm or corporation which entrusted or accepted the agency. Okay, so pag nawala na yung corporation or the firm which granted the agency, wala na rin yung contract of agency. Number 5, by the accomplishment of the object or purposes of the agency. So let's say ang SPA is to sell the property. Pag nabenta na yung property, tapos na yung contract of agency. Alright? Number 6, by the expiration of the period for which the agency was constituted. So ito class, no? Pag merong expiration yung SPA, alright? So pag tapos na yung period na yun, tapos na yung contract of agency. Okay? Pero may expiration nga ba? As a general rule, may expiration ba ang SPA? The answer is no. Okay, there's no expiration. So the SPA will be without force and effect if what? If the SPA was revoked by the principal or if the agent withdraws. Ano pang isang bagay? Wala na yung SPA na yan kapag nabenta na yung property or kapag namatay yung principal. And the agent, of course, kasi sino ng agent kapag patay na. So pag namatay yung principal, wala na rin yung SPA na yan. Alright? So when is the agency irrevocable at will? So class, the general rule is the contract of agency is revocable by the principal at will, no, at any time. However, there are certain exceptions. So what are those exceptions? When the agency is created not only for the interest of the principal, but also for the interest of third persons. When the agency is created for the mutual interest of both the principal and the agent, or if it is the means of fulfilling an obligation already contracted, and when the agency is coupled with an interest, when the agent is parted with value or incurred liability. Okay, so these are the exceptions. So right of agent to withdraw. Agent may withdraw from the agency at any time, whether he or she is unpaid or paid. So because there's a prohibition against involuntary servitude. There should be paid class. No? Please forgive the typographical error. If the withdrawal is without just cause, the agent must indemnify the principal if The latter suffers damages. Okay, but in any case, the agent can always withdraw. So class, we end here. So that those are the basics of a contract of agency. So study well for your exams. Good luck and God bless. And keep safe.